Hello, good morning, students. Please subscribe the channel, drop a like, share, and comment. This is Shree Vishnu Art Press Publications, exercise number 1 and 2 on the speed of 90 words per minute. Start. Challenge in this appeal is to the order passed by the Division Bench of the Punjab and Haryana High Court dismissing writ petition filed by the appellant under Article 226 of the Constitution of India 1950. Prayer in the writ petition was to quash the award dated 23/9/2004, under which the respondent number 1 was directed to be reinstated with continuity of service with 50% back wages within stipulated time. The award was made by the presiding officer, Patiala. The matter was before the Labour Court on the basis of a complaint made by respondent number 1. The brief facts of the case are that respondent number 1 workman was appointed as bulldozer operator with the petitioner management on 1/11/1990. Since his appointment was on 89 days basis, the same was extended from time to time till 5/7/1996. Thereafter, his services were not extended. The workman raised an industrial dispute on the ground that his services were terminated by the management on 15/7/1996 without any notice, charge sheet, inquiry, or compensation, and that the juniors to him are still in service of the management, and new persons were also appointed by the management after terminating his services. The government referred the dispute to the Labour Court for adjudication under Section 10(1)(c) of the Industrial Disputes Act 1947, and the Labour Court on 23/9/2004 made the award, which was challenged before the High Court. The stand of the petitioner management is that respondent number 1 workman was engaged as bulldozer operator on 89 days basis, and in that stopgap arrangement he had worked from 1/11/1990 till 15/7/1996, but intermittently. He was never employed continuously, therefore did not work for 240 days in the preceding 12 calendar months. Thus, denial of further extension of his service does not amount to retrenchment, therefore has been wrongly awarded reinstatement with back wages. The Labour Court has not appreciated the fact that since the petitioner department is not an industry, the services of respondent number 1 were not governed by the aforestated Act. The Labour Court held that Section 2(o) of the Act has no application to the facts of the case. In any event, the workman had completed 240 days of work in several years. The appellants took the stand that respondent number 1 have not completed 240 days of work in any calendar year. He never worked continuously. The employer was not an industry. The Labour Court held that there was no compliance with requirement of Section 25F of the Act. The question whether department is an industry has to be decided against the management for want of evidence. The onus was on the department to prove that the workman worked only 180 days and not completed 240 days in the preceding 12 calendar months from the date of alleged termination. Since no records were produced by the department, the claim has to be accepted. In the writ petition before the High Court, it was categorically urged by the appellant that no appointment order was produced. In each of these cases, challenge is to the bail granted to the respondent by the Bombay High Court Nagpur bench. Since all these appeals have a common matrix, they are taken up together on the basis of allegations that the respondents were guilty of having committed cheating, preparing forged and false documents for the purpose of cheating, using the said documents as genuine, abetment of crime, committing criminal breach of trust by forming criminal conspiracy in furtherance of their common intention, law was set into motion. They were convicted by the trial court and have preferred appeals before the High Court and had prayed for grant of bail by suspension of sentence in terms of Section 389 of the Code of Criminal Procedure 1973. The High Court primarily granted bail to each of the respondents on the ground that bail was granted during trial and the liberty was not misused. Further ground indicated was that there was likelihood of delay in disposal of the appeals. In the case of respondent, it was stated that the evidence appeared to be scanty against him. Questioning correctness of the order passed in each case, learned counsel for the state submitted that there was large scale of manipulation of records resulting in manipulation of results of the candidates, and each of the respondents had a definite role to play. Apart from the cases where they have been convicted, large number of connected cases are also pending. In the case of respondent Madhukar, two cases under the Prevention of Corruption Act 1988 were pending. In one case, the said accused had offered bribe to the investigating officer and was caught red-handed. It was submitted that considering the gravity of the offence, the sentences were directed to run consequently in terms of Section 31(1) of Code. It was stated that the High Court was misled in the case of respondent Janki, who made a false statement before the High Court that he had deposited fine amount, while in fact he had not done so, as would be apparent from the second order. It was essentially submitted that without indicating any plausible reason contemplated under Section 389 of the Code, The bail has been granted. The seriousness of the allegations for which the accused respondents have been already convicted has been completely lost sight of. Learned counsel for the respondents, on the other hand, submitted that the parameters for grant of bail and cancellation of bail are different. It was submitted that some of them are very elderly persons and have retired from services. It is not a case where any irrelevant factor has been taken into consideration. It is pointed out on behalf of respondent Madhukar that the said accused is stated to have centers round two chits which were exhibited. They did not in any way establish the involvement of the accused in the alleged crime. That is why, in his case, the High Court observed that the evidence is scanty.